Hey guys, welcome back. And this is the last section of our review of the Dignity Act, which is going to include all of our exploration into Division C, Division D, and Division E of the Border Security for America Act, which is focusing on improving seasoned guest worker opportunities, the American Agricultural Dominance Act, and the American Prosperity and Competitiveness portions of the act. Let's dive deep into the key provisions of each of those. Division C of the bill aims to improve seasoned guest worker opportunities. One significant provision is to the expansion of the statutory definition of returning worker. This expansion would include any worker who entered on an H-2B visa in any one of the previous 3 fiscal years. The bill also authorizes the Department of Labor to investigate and take action to ensure compliance with the H-2B program. It establishes a complaint process and allows the imposition of remedies, including a temporary or permanent disqualification from the program in entirety for multiple violations. Additionally, the bill requires H-2B employers to develop and maintain worksite safety and compliance plans. They don't want people taking advantage of these seasonal workers. It also prohibits employers or recruiters from receiving fees for the recruitment of H-2B employees. That's essentially tantamount to human slavery. Moving on to Division D, also known as the American Agricultural Dominance Act. This is the section that introduces the Certified Agricultural Worker, also known as the CAW. The CAW visa is a new uncapped temporary worker visa program specifically for current unauthorized farm workers. To qualify for the CAW visa, unauthorized immigrants must have spent at least 180 days of the last 2 years in agricultural employment. For those who have not worked enough days to qualify, additional H-2A visas would be made available for those who have worked at least 100 days over the last 3 years. After successfully maintaining either 8 years of CAW status or 4 years of CAW status plus 10 years of previous agricultural work experience, unauthorized farm workers would be eligible to apply for lawful permanent resident status, or LPR. In Division E, titled American Prosperity and Competitiveness, the bill proposes updates to the U.S. legal immigration system with a focus on protecting family unity, reducing backlogs, and improving employment-based opportunities. That includes the EB-5 investor program. One key provision is the exemption of spouses and minor children of lawful permanent residents from current family preference green card caps. This means that the annual visas that normally go to spouses and minor children of LPRs would be reassigned to other family preference categories. That would be increasing the number of available visas significantly. The bill also aims to eliminate backlogs by reducing the maximum waiting time to 10 years for individuals who have been waiting in the backlog, whether for family or employment-based visas. Those who have been waiting for over 10 years will receive their visa. That's a significant departure from previous policy where you saw H-1B visas, which turned into EB-2 green cards. Some countries, like India, are waiting almost 80 to 100 years in their backlogs because of the demand. To get a 10-year cap on a backlog would also hit people that are from China applying for EB-5 back from 2015. Significant improvements across the board. Another important provision raises the green card per country cap from 7% to 15% of the total number of employment-based or family-sponsored preference visas each year. This change aims to reduce and eventually eliminate country-specific backlogs when combined with other reforms. The bill also includes measures to protect documented dreamers from aging out of status once they turn 21 due to delays in visa availability, and also grants greater flexibility to F1 student visa holders by making F visas dual intent visas. Furthermore, the bill addresses employment-based visas by preventing derivatives, which is children and spouses, from being counted against annual visa totals. This provision could potentially increase the annual number of high-skilled worker visas by 50% without even raising the visa caps. If you think about it, a family of 3 with only 1 petitioner essentially sucks up close to 200% more than the allocation that was originally provided to it. By eliminating derivatives, you're going to increase the de facto cap significantly. To enhance efficiency and reduce backlogs, The bill creates an immigration agency coordinator to oversee the immigration functions at USCIS, the Department of State, and the Department of Labor. Additionally, it authorizes approximately $3.5 billion to improve processing and reduce visa and work authorization backlogs. That's a significant amount of resources that USCIS never had. That concludes our overview of Division C, Division D, and Division E of the Border Security for America Act. If you found this information helpful, please